At the moment, we're just waiting to live stream in the various participants who are going to be joining us and are at this very moment joining us. So as I mentioned, this is the first time this conference has been able to incorporate the participation of people through the internet, and we have Olelo to thank for that. So I think at this point, we would like to begin the conversation portion of the Davis-Levin First Amendment Conference. That's what this conference is all about. It is about having a conversation that is protected under the First Amendment, and that is what we are doing here today. And we are joined by Edward Snowden, and you'll see him very shortly, as well as by Ben Weisner, who is his ACLU counsel. The conversation is intended to incorporate you as participants through the means that we mentioned earlier, the notes of paper, and then also through that Twitter account, that hashtag, which I'll find for you in just a moment, DLFAC2015. Also, the conversation is going to be moderated very ably by Dean Aviam Soifer, who is the Dean of the University of Hawaii at Manoa Law School, the William S. Richardson School of Law. So I think at this point I will go ahead and invite, well, before we do that, I'm going to invite Mark Davis, who is obviously one of the founding members of Davis-Levin Livingston, and he's going to get up on stage and say a few words for us first. Thank you.
Thank you very much. We have confirmed that the NSA was not responsible for our technical difficulties earlier. We have not confirmed that they're responsible for the weather. On behalf of our law firm, I wanted to just say a word of thanks to the many people that were behind this meeting who worked so very hard, including Kent Grant, Vanessa Chong, the many volunteers at the ACLU who have worked so diligently to put this together. Our partnership with the ACLU started in 1997. It was the brainchild of a guy by the name of Bob Reese, who, if you don't remember who he was a columnist, a contrarian, a pundit. He wrote columns in Honolulu Weekly and the Advertiser and the PBN, and he cared little about who he offended, but he always spoke his view, and he believed very, very strongly that of the importance of having this free marketplace of ideas. We had the good fortune of representing him in a battle that he had in which government was trying to restrict his ability to write his columns. And in order to celebrate, he came up with the idea of having this First Amendment conference. We don't have it every year. We only have it when we feel there is a hot button issue that is appropriate to bring to our community. One of our first ones had Justice Scalia debating the national president of the ACLU in his first public appearance following Bush versus Gore. We had Kenneth Starr right after he stepped down as special prosecutor during the Clinton administration, also debating a civil libertarian for our community. We've had serious and interesting discussions about the role of religion in government when we had some of the leadership of the Christian Coalition in one of these programs. And Bob believed and seemed to understand that there was an appetite in this community for presentations such as this. And his thoughts are very much confirmed by the extraordinary turnout today and our ability to now stream this over the web, this conversation. The audience that is here from our community consists of students, professors, the old guard ACLU types. We have a strong contingent from the military. We have some from the FBI and the Homeland Security, all of whom had to buy their $5 tickets, all sitting next to each other in the same room, watching the dean of our esteemed law school interviewing the most famous fugitive in the country. So I think that Bob must be smiling about that turn of events, and we are proud to be a part of it. So without further ado, I want to invite the participants, Dean Seufer and Ben Weisner. Thank you very, very much for your appearance.
There he is. Aha.
I don't know if we can get us both in the phone.
They're standing at 800 people standing.
It's incredible. I got to say, really, thank you so much to everyone. You can't tell, but you actually clapped so hard that it shook the laptop, and my view was bobbing up and down.
Well, aloha and welcome home to Hawaii.
Aloha. Thank you so much. Mahalo.
Ben Weisner is an old friend of mine. He's not very old, but he is an old friend, and it's nice of him to come even now that he's a matinee idol, having been in that wonderful film. So we're just going to have a conversation. First question that I have really for both of you is, has Congress reacted, and if so, in what way? You're very optimistic about the American people and public opinion. Have you seen some progress?
You want to go first, Ed?
Yeah, I think when we look at what's happened with Congress, there's really been kind of a sea change. The first and most important is awareness and accountability. When we sort of rewind the clock back to 2013, before anybody knew about this, the only members of Congress who really understood what was going on were a very few select members in the House and the Senate Intelligence Committees. Of these committees, only 4 of them got briefed on all of the details of covert action programs, like the really dark special source operations programs. So the whole idea of sort of checks and balances in our government, where we have legislators who write these laws carefully to restrict the powers that are available to the executive, and the courts make sure that the executive isn't sort of cheating and going too far. None of that was happening. We saw that broke down in a lot of ways. Actually, this is something that's come up a lot. In 2013, right before, there was a case, ACLU, the Clapper, actually, where they were challenging these mass surveillance regimes. And it got all the way to the Supreme Court, and the Supreme Court said, we can't rule on this. This is too secret, and because you can't really prove you've been spied on, because it's a secret program, and of course there's no evidence, there are only claims of surveillance, we can't look at it. Now, they say we do have a secret court, and they'll sort of regulate it and look at things like that, but when we look at that secret court, we see that over 33 years that it had been in existence, it had been asked by the government 33,900 times to spy on people. In those 33,900 times, over 33 years, they only said no 11 times. And now, as soon as that information came out, Congress changed their tune. They came after me personally, which is fine, because ultimately, if people want to call me names, that's okay, right? If you're afraid to be called a few bad names to serve your country, you really don't care that much about your country. But now, we have new cases all throughout the court system. We have congressmen pitching new sort of reform bills and authorizations that are still quite weak. I mean, I have to say, they're really tentative, they're really careful, because nobody in Congress wants to be seen as soft on terrorism. They don't want to be seen as weak. But what is sort of weak there is a sea change. It's a radical improvement. And as long as they know that we, sort of the public, are watching what they're doing, and as long as they see that we care about our freedom of expression, our freedom of association, our freedom from unwarranted suspicion and from unreasonable search and seizure, we can force Congress to do what we want. We can force them to represent us because ultimately, at the end of the day, we have a power that they don't, thanks to advances in technology that are sort of becoming more mainstream. And our technologists, are working on it, our academics are working on it, and people in the audience are working on it. Most people in the audience now today have heard of encryption. Prior to 2013, that wasn't a given. A lot of them have heard about anonymous routing technologies like the Tor network or virtual private networks. They know that there are encryption apps for your phone, like Red Phone for the Android, Secure or Text Secure, which is, I believe, for both that and Apple phones, or Signal for the Apple phones, all of which are free. But means suddenly the government can't monitor all of your calls and all of your texts just as they cross the global network. They have to actually go to a judge, get a warrant, and target you specifically instead of targeting us all the time. Now, this dynamic, where suddenly we can start to enforce our rights, not just through black letters on a page, but through the actual standards and systems that surround us in our lives every day, the cell phones in our pockets, the laptops on our kitchen tables, we can put the government on notice that if they will not be responsible stewards for our rights, we the people will do it ourselves. And now, for the first time in history, we have that power. And because of that, I've got a lot of optimism about the changes we'll see in the future.
Thanks, you want to?
Yeah, I think so. I think that the question was about Congress. You see in the first part of Citizen 4 in the film, the top leaders in the intelligence community going before Congress and saying under oath that the NSA, the intelligence community, was not collecting any kind of data on millions of Americans. People have described that as those people lying to Congress, but I think that's actually misleading. The members of Congress who were asking the questions actually knew the answers and sat there while they were lied to, but the people being lied to were us, not the members of Congress. This was a real failure of Congress. You even had the most concerned overseers, Senator Wyden from Oregon, saying, if the American people knew what I knew about how the Patriot Act is being used, they'd be shocked and they'd be angry. Well, that turned out to be true, but we didn't learn it from Senator Wyden. We learned it from Ed Snowden. One of the Republican authors of the Patriot Act, James Sensenbrenner, when he saw these stories, he said, that is not what we meant when we gave this authority. When we said that they could get relevant information to an investigation, we didn't mean they could take all phone records and then decide later what was relevant. And in fact, Representative Sensenbrenner has filed a brief in support of the ACLU's litigation against the NSA. So that doesn't mean that Congress is ultimately going to deliver legislative reform that we think solves all of the problems. What it does mean is that Congress is going to debate openly with an informed public about what the limits of the NSA's spy authority should be. Now, that should have happened 10 years ago, 12 years ago, before this regime was deployed. We now have that chance. Edward was not confident of any particular outcome. What he was most concerned about was democratic participation, was that we be able to have this debate with full information, and that we have now.
I think the film very powerfully shows how much data is being collected. I want to thank the techies who made it possible for us to get there finally to the end of the film, and all of you for being so patient. I'm reminded a variation on the theme of a professor I once had. You could sum it up by saying, anything you can do, we can do meta. But of the documents that you collected and gave to the media, what proportion do you think represented illegal activity? Is it a lot, some, a few?
I'm sorry, I didn't get the last.
The question is, of the documents that you gave to the media, what proportion represent illegal activity by NSA or by others?
I think the question of unlawful activity is best sort of answered by the government and by the people. Now, we don't need to know, every single program that's out there. We don't need to know the name of every target, every individual who's under surveillance, or every capability we have. But we do have to understand the broad powers and sort of prerogatives that the government is claiming, because this is what they're using in our name, and this is also what they're using against us. And this is really significant because when we talk about these powers and the illegal programs, the unconstitutional programs, like what Judge Leon ruled in the U.S. federal court in Klayman v. Obama, I believe it was last year, was that, yes, there are a number of programs that are truly unlawful, where they simply don't have a reliable statutory basis, and the White House's sort of review groups that looked at this confirmed this. The Privacy and Civil Liberties Oversight Board reviewing the Section 215 sort of bulk phone monitoring program, the one that when you pick up the phone right now and call somebody, it keeps a record of that call, of your private calls to all of your friends and associates and loved ones. Regardless of what you're doing, regardless of whether you're suspected of any crime, it doesn't record what you say on the phone. But we don't really need that because, as you said, metadata, metadata, metadata. And that was the government's defense here. They said that, guys, cool down, relax. It's just metadata. It's just metadata. We're not hearing the words you say on the phone. We're just collecting basically the associational records. Who you called, when you called, what time it happened, how long it was for, these kind of things. But this is analogous to the information that a private eye collects when they follow somebody. If I'm a private eye and I'm following someone around, surveilling them, I don't sit close enough to them in the cafe, typically to hear every word they say. But I absolutely know who they meet with. I know where they met. I know how long they met for. I know where they were headed afterwards. That's all metadata. And what's critical about this is the fact that when we look at the admissions of people who worked for the NSA in very senior positions themselves, the general counsel, sort of the top lawyer for the National Security Agency, Stuart Baker, said that metadata is a proxy for content. It tells the story of all of our lives. When you have enough metadata, and you sort of weave it together into this rich tapestry with everybody else's, you know what the content was, even if you didn't record it. And Michael Hayden, the former director of the NSA and CIA, I worked under him once, he said that we kill people based on metadata. And so the idea how this fits together is that, for example, if I'm an analyst sitting at the desk and I'm looking at somebody's call change, their sort of call data records, and I'm trying to figure out what's going on with them. And I see they've got, a call record to a certain person that's been going back years and years and years and years. I know that person is probably family. Then I see, this person is calling female hair salons and things like that. I know they're likely female. Now I see suddenly they start getting a new call. This is somebody new they've met, some new association on the cell phone, calling them, talking real late at night, 2 hours, 3 hours. And then eventually, when I'm looking at the cell phone location records, which are also being collected, I see that these two cell phones are now spending a lot of time together at night. You realize it's very likely a romantic partner. But then you see that phone association stops. That phone call, that cell phone that used to be, spending the night with that unknown female is now no longer there. But that phone call suddenly gets called by a health clinic. And then that person calls that family member late at night for a very long time. And then it goes dark for a while. And then that person calls an abortion clinic. Even though you haven't got a single bit of content in any of that, you don't have to be a scientist to figure out the story of what's going on there. Now, this person was not suspected of any crime, yet that information, that intensely private information, was collected automatically, programmatically, without any involvement at all. And so the National Security Agency, Congress, the President, and in certain cases, they go, look, we're not trying to watch everybody. And this is true, they're it exists. We've built it, and it's operating today. Anybody can flip this switch because we don't have legal restrictions that are enforceable that are being used. The NSA was found, NSA employees have been found on multiple occasions, I believe 11 occasions, to have used sort of our mass surveillance programs to target their romantic partners, basically. They wanted to see if their spouse was cheating on them. They wanted to read their emails. They wanted to see who they were talking to, who they were texting, that kind of thing. It happened 11 times. None of these people were tried in court. Because the government naturally, the same way they shut down the Supreme Court case, they say, look, the secrecy of these programs is more important than the accountability of the people who are overseeing them. This is what we saw with James Clapper raising his hand in front of Congress. He gave false testimony to Congress, even shy of perjury, which is a particular charge. Giving false statements to Congress is itself a felony. Yet he wasn't tried, and this is the most senior intelligence official in the United States. Why would we hold the most senior people in our country to a different standard of lawful behavior when they have greater powers than the ordinary citizen than we do those ordinary citizens? We're creating sort of an unequal justice, and this is, I think, less about surveillance and more about democracy. Because when we have a government that starts to sort of ease away from the oversight and responsiveness to public concern by bringing themselves under sort of a blanket of secrecy, what this means is that our ability to meaningfully regulate the behaviors of our government, our ability to meaningfully guide the direction and future of our democracy is diminished. And once we start to accept that incremental decline step by step, and for good reasons, we say we want to be safe from terrorism, we want to be safe from criminals, we start to lose that. And it's critical because if we cannot say in the very few times we do have evidence of real, serious government violations of law, that we don't actually hold these very high, powerful officials to the same account that you or me would be held to. As private citizens, if we hacked, our spouse's email instead of sitting behind a government desk and hacking our email, that's a step that we can't come back from. And ultimately,
let me jump in here.
Sure, go ahead.
And answer this question in a slightly different way. The question being, what percentage of these disclosures revealed illegality? And I would turn that around and say, how do we decide in a democracy, typically, whether the actions of the executive are legal or constitutional or not? And one way that we do that is that we bring cases to federal courts and we ask federal judges to look at the government conduct in light of statutory authority, in light of the Constitution, and get a ruling from a neutral magistrate about whether the government has violated the law. Now, every single time we try to do that, with respect to an NSA surveillance program, up until June of 2013, when these disclosures occurred, those cases were thrown out. And they weren't thrown out because the court said that the NSA was acting legally. In fact, the NSA didn't even argue that it was acting legally. The NSA said this program is too secret to be litigated. You have no evidence that you're being spied on, so you have no legal standing to be in court, and you can't get that evidence because it's a state secret. A lot of people say Edward Snowden should have gone through the system. He should have gone through the system rather than around the system. Well, I went through the system. The ACLU tried to go through the system for a decade before this, and the system spat us out. And just a few months before these June of 2013 disclosures began, the Supreme Court, in a 5-4 decision, essentially said that neither we, there it is, my client and my assistant, that we didn't have legal standing to be there, and therefore no one had legal standing to be there. So I think that's an important context for your question. The second piece of context here is that I think that there is a presumption among some people that the disclosures that show clearly illegal conduct are legitimate, and the ones that show conduct that most courts have deemed legal are illegitimate. But I think that's the wrong standard. And I think the question in a democracy is this information that the people have a right to know and that the people have a need to know? The NSA is a huge part of the United States military. We should presumptively know what they're doing, at least in general terms, unless there are very, very specific and narrow reasons why we shouldn't know that. And that's been inverted. And so I say, why was this information withheld? Not did these publications show illegality. I mean, sometimes the scandal is the government breaking the law. Sometimes the scandal is what the whole system considers legal.
I think this is a follow-up, and it's a Twitter question, so I'm doing that in part so you can see that the Twitter question mode works. Part of it I think you've already answered. Do you think anything has changed since Glenn broke the story? But the second part I think is directly relevant to what you were each both saying. Any strengthening of protections from surveillance?
Well, let me start here, and then I think the second part is especially suited for Ed. I think the biggest change, and this goes back to the very first conversation that Ed and I ever had, one of his first questions for me in July of 2013 was, do you have standing now? Meaning, can you now go into federal courts and ask them to do their job instead of abdicating? And in fact, there are now 3 federal courts of appeals that are considering whether the NSA's program of collecting all of the metadata from Americans' phone calls and storing it for 5 years is constitutional. Now, the government is still trying to argue that we don't have standing, but those arguments are a lot weaker when we have documents, court orders showing conclusively that our data is being collected and stored. So that in itself, and I want to say this, regardless of outcome, I mean, I obviously have very strong ideas about how these cases should be resolved. But to me, it means something that federal judges are going to be deciding these cases on their merits instead of saying it's not our job to do this because it's too secret. So that in itself is a big change. And I'm going to turn it to Ed because there's been another set of changes that have less to do with democratic reforms, but more to do with how the technology community has kind of woken up to a new threat model and responded to it.
Right. I would, just to tag on to that, I would say the top line largest change in the legal context is similar to what Ben said. We've moved sort of the challenges against these programs from secret courts, unaccountable courts, these rubber stamp FISA courts, to open courts. You know, and that by itself is worth it right there. But when we look at the technical side, there are significant changes. Protections are being raised around the world. But actually, back on the court issue, it's also not restricted to the United States. This is a global phenomenon that's now happening. The United Kingdom, they have their own sort of secret court, like our FISA court, that's existed for 15 years and never once in 15 years ruled against the intelligence agencies. Only about a week ago, they ruled for the very first time in 15 years that their NSA in the UK had been breaking the law for 7 years. That's a significant change. This stuff never would have happened before. Now, on the technical side, we see significant changes where corporate America has really changed their tune. They were quietly, secretly asking the government for liability protections where they could be excused from being sued, basically, for handing your data over to the government, or they were being compelled by the government through special laws and things like that, secret processes, to give all of the information from your Facebook account or your Gmail account over to the government. And these were actually one of the first things that were revealed. It was called the PRISM program. And right here at the top, you can see the different logos of all the providers. I think you're already pretty familiar with all of these. And it was happening both across the internet backbones, and it was also happening at the providers themselves. Now, this has changed radically. The president, just a few days ago, had a summit in Silicon Valley where he was supposed to meet with all of the sort of top technology executives in the U.S. Google CEO, Facebook CEO, but most of them canceled. Only the CEO of Apple showed up. And when he was there, instead of saying, yes, let's partner on this new cybersecurity legislation, which is really asking for liability protections for what's called information sharing, where they can hand transactional records about activities on their services over to the federal government, again, without being sued, without you having any enforcement rights in the court. Rather than talking that up, he talked about the right to privacy. He talked about how it was a fundamental right. He talked about how it doesn't take long for an American to look back at history and realize that when we disempower the public relative to the government, and we're not really focused on what's right, instead we're simply focused on what's lawful, what's legal, that goes downhill really quickly, and it puts individuals at risk, and that's a common dynamic that we see in history that means we end up in trouble. But on the purely technical side, stories revealed, for example, that the NSA had broken into Google's backend that connects their data centers. So, for example, a data center in this city and this city are connected by a line. The NSA didn't feel that it could legally break into Google's data center itself, but they did feel that they could break into the line, so that's what they did. To fix that, to protect us from that sort of backdoor law-evading way of gathering information, and instead forcing the government to go, look, if you want something from Google, just knock on the door and hand them a warrant. They've encrypted that line, which on a technical basis says you can no longer just sort of intercept and read that information in bulk. You've got to go through legal process, you've got to go through the courts, and that's what we want. Because it's not that surveillance is evil. It's not that surveillance in all cases, is this great danger. We've had wiretaps for hundreds of years, and they've been effective even though we knew they were taking place. We want the police to be able to intercept the mafia's phone calls. But they do that by going through a court. They don't need that to be secret because mobsters still need to use the phone sometime. They still need to communicate sometime. And because of this, we've been able to sort of change the technical paradigm where we raise the costs on mass surveillance, on targeted surveillance, by basically limiting access to those lines, the bulk communications that are sort of electronically naked as they circle the world, and say, if you want to go after somebody, you have to target them. You have to look at this person specifically. You can either go to the communications provider or the service provider and try to get them through some process, or you can seek a warrant to hack the endpoint, to hack the criminal's cell phone, to clandestinely enter their home, land an audio device or something like that. And we see that it works. Despite the fact that the FBI and some members of Congress and things like that have said encryption is terribly dangerous. It means we're not going to be able to investigate effectively anymore. If criminals combine anonymization technology and encryption technology together, we won't be able to catch them. But we know this is not true because just a few days ago there was a landmark case that closed, it finished up in the United States about something called the Silk Road, which is an online encrypted drug market, or was, where people would use anonymization technologies, encryption technologies to purchase drugs through the internet or other things like that. And the mastermind, the alleged mastermind, who was convicted on all counts, was convicted because despite the fact that this individual was using incredibly sophisticated encryption that based on the NSA's own documents we know they could not break, and they were using anonymization technology, the prosecutors were reading this individual's encrypted diary out in the courtroom. And that's because regardless of the fact that data can be encrypted, if data is always encrypted, the criminal themselves cannot read it. The difference between an encrypted page and a decrypted page, obviously, is readability. Same thing with a photo or anything else. If the criminal wants to be able to access this data, they have to unlock it. They have to decrypt it. And if this is part of a criminal enterprise, if this is part of a criminal act, we can monitor this person, we can follow them, and we can seize this device when it's in operation, or we can subvert it electronically to steal the keys, which allow us to access it at our leisure. And this is happening all the time.
So Ed, can I
to summarize? Yeah.
Well, I was going to summarize, and you can tell me if I'm summarizing correctly, that technology companies and technologists have woken up to all the ways in which the NSA and its other counterparts have broken into their systems. They have taken steps to increase encryption, to increase protection. That's made it much more difficult for these spy agencies to collect all of our information and store it forever. But for legitimate investigations, they still have the capability to be able to do it. So it's not as if we've tied their hands behind their backs with encryption. If they really need something, they'll be able to get it. But we have made it much, much more difficult for them to create these vast surveillance time machines that essentially just suck up all of our communications and store them forever. How's that?
Yeah, that's perfect. I mean, the fundamental argument that we see happening in the policy circles today are they're trying to put privacy and sort of our associational rights on one side and then security on the other side. But it's not really the same, particularly in the context of cybersecurity. Security and protection of rights go together. Surveillance and security are what are the opposing forces. And this is what we're seeing people realize increasingly around the world. If we want to protect our services, if we want to be able to protect our products, if we want to be able to sell an iPhone overseas, or if we want somebody to use a Gmail account or any sort of American product, they have to be able to trust it. They have to be able to know it's secure. And they have to be able to know that it's not sort of this all-you-can-eat buffet for governments around the world to tear through it whenever they want. And this is increasingly becoming the standard because you're not going to buy an American phone which is completely vulnerable and leaves you with no protections whatsoever if other countries sell equivalent products that are actually secure. And corporations naturally get this because ultimately sales equals money equals happiness for them. So we're headed in the right direction in terms of corporate America.
Okay, so this is, I think, a very good follow-up to that. This is someone asking for advice and says, of course, we should work to change the policy, but I guess one could say, what should a private citizen, using the term in several different ways, what should a private citizen do? More of us hiding from surveillance or more of us defying it and in that effort not attempting to hide?
This is an interesting philosophical one, but first off, I want to take the political angle. Ben, why don't you cover the activist sort of approach? How do we change the policies that are sort of so corrosive that we're dealing with right now?
Well, yeah, I think that so part of the question is how much of the response to this should be what we call digital self-defense, individuals taking steps to protect themselves. And I have mixed feelings about that as an activist response. On the one hand, the more people who use encryption tools, the less the people who do use them seem like the ones who have something to hide. If 15,000 people in America are using a privacy protective technology, they're a very easy target for law enforcement and spy agencies who will assume that they're up to no good. But if millions of people do it, there is more herd protection for it, and it raises the overall cost of the kind of mass surveillance that we don't like. But having said that, I don't think that we should be putting the burden on individuals here. I think when Google flips a switch and goes to encryption by default, that offers protection for millions of people, and they can do that really with very, very little effort. And so that's where I think the activist energy, much of it has to be directed at government, but it should be directed at the companies to whom we entrust our data, to the Googles, to the Facebooks, to all of these companies that essentially give us services in exchange for letting them spy on us. But we do need to tell them that they need to be much more active in being custodians of our data in the face of government attempts to collect it all. Ed?
Yeah, I think that covers it pretty well. We have to sort of draw a balance between the burden of knowledge that we want to put on individuals versus putting on our social structures, our systems that we rely on to really ease this up. Because you don't want, a doctor, you don't want a grandmother, you don't even want, an ordinary person who's got a natural proficiency for technology. Young people who have cell phones in their pockets all the time. To have to learn to be this kind of expert digital insurgent, just to be able to read the kind of things they want to read and talk to the people they want to talk to without having those communications monitored and judged in advance of any criminal suspicion. That's not the kind of world we want to live in. So while there are a lot of ways you can increase this, you will never be 100% safe against an intelligence service as an ordinary citizen because just of the imbalance of power there. The intelligence community in the United States, as of 2013, had a $75 billion a year budget. That's if you count military intelligence spending along with the non-military. And when you look at that compared to your resources, it's naturally there's not much of a balance there. So I would say most important thing you can do on the short-term, small scale is support companies that actively resist the subversion of individual and consumer rights. You know, if you see a company that's saying, we're going to make our products more secure, we're going to encrypt your devices by default. If the government brings a novel sort of legal request to us for information on masses of people, or they want to put a backdoor in our communications, pledge that you will not use services that work against our collective rights. It's really that simple.
This person wants to know, and the film makes clear your opposition to broad worldwide surveillance, but this person wants to know what proportion of the documents you release to the media are of that sort, what proportion of them are discriminating, are targeted?
Most of the programs that we look at that have been reported are about mass surveillance or basically questionable surveillance, things that are deceptive policies on the basis of our government's relation to our people. There are no stories, I think, that have been published that the government hasn't seen in advance and agreed that there was no harm to, there was no, immediate harm, life and limb. An agent was going to get hurt, soldiers would be put at risk or anything like that on the basis of publication. And this is what I think that question is really getting at. A lot of people are uncomfortable with this to some extent, and this is reasonable. The government says these are classified programs, these are secret programs, so we have a natural proclivity for believing them. We trust the government, and I've trusted the government for a very long time. In 2004, when the Iraq War was going on, I signed up to be a part of it because I believed that the government's claims about the basis of the war were true. These kind of casual deceptions that happen on the basis of government are very corrosive to the structure of our government and our relationship with it. And if we can't understand when we are being deceived, we can't really have a participatory democratic model of government at all. So when we think about proportion of documents and how things are done, I think it's more important to focus on the model of publication, which is that the documents were reviewed for revealing some form of wrongdoing. That doesn't necessarily mean illegality. Whistleblowing in the government is defined not as revealing unlawful programs. They're wasteful, fraudulent, or abusive programs, and I don't think there has been any pushback on those. And when we look at the publication process, those documents then went to institutions of journalism. They were given to American newsrooms, and they went to the government and they said, "We're going to publish these documents. Is there anything in them that, despite our best intentions, we may have overlooked some detail that would be very dangerous to national security, that we could hold back and still publish the story while protecting national security interests and individual security interess?" And that process has been followed uniformly, and I don't think it's been departed from. Beyond that, when we look at the claims of, did these disclosures cause harm? Did they damage national security? Is there some real risk we need to worry about? And, we can look at the NSA director's words themselves. The new NSA director who replaced Alexander, Mike Rogers, just last year in front of Congress said that despite all of these disclosures, despite the fact that they were classified, the sky is not falling. We're not in extraordinary danger. We haven't lost sight of all the terrorists in the world. Our service members are not being picked off on battlefields around the world as a result of this. And this happened in 2013. We're now in 2015. If the government had some evidence that this were the case, I can assure you they'd put it on the front page of the New York Times by now. Beyond that, we have academic reports, independent reports, that show some of the claims that congressmen had made to newsrooms to try to sway opinion were in fact not true. One of the primary ones was that terrorists had changed their communications as a result of these disclosures. And when we looked at independent reporting, as opposed to the original CIA-funded report through a venture capital group called Incutel, they found that terrorists had in fact not changed their methods of communication as a result of the disclosures. But beyond that, I'll say this. Osama bin Laden is, the terrorist's terrorist. He's Al-Qaeda. And all of these other terrorist groups learn from a common body of knowledge. They weren't surprised by this. The idea that the NSA was monitoring the internet, was monitoring cell phones, was not new to them. Osama bin Laden stopped using a cell phone in 1998, not 2013. Moreover, there have been a number of interviews for decades now looking at terrorists, and they say, we don't use cell phones anymore. Why don't we use cell phones anymore? I don't go to this internet cafe anymore. Why don't I go to this internet cafe anymore? And the answer that they give is because all of my terrorist friends that had cell phones are dead now. This is not rocket science. You don't need the New York Times to tell a guy in the desert that all of his friends that have cell phones got hit by hellfire missiles. So there are reasonable concerns, and it's natural to question these things. But ultimately, if we're going to have a discussion, we have to ground it on the basis of facts. And when you look at the record, it's now 2015, and there has never been any individual case of harm that has been shown as the basis of these disclosures.
There's another side to this question that may or may not have been implied by the question that you read, and that is the question, who decides what the public should know? And the argument that you hear from government and intelligence and military circles has a lot of logic on its face. And their argument is this. Obviously, there have to be some secrets, even in a democracy, which everyone in this room, I think, probably agrees with. The people who should decide what's secret are the people who have been elected by the public to make those decisions, and the people who have been appointed by those elected officials to make those decisions. That does have a surface logic, but let's do a little thought experiment. Let's consider what we would have known and not known in the last 15 years if we had only known what the government, elected officials and appointed officials wanted us to know. We wouldn't have known that the case for war in Iraq was fraudulent and contrived. We wouldn't have known that prisoners were tortured in Abu Ghraib. We wouldn't have known that the CIA had set up a network of secret prisons and dungeons around the world and subjected prisoners to barbaric interrogation techniques. We wouldn't have known that the NSA under the Bush administration decided to disregard law altogether and just conduct a warrantless wiretapping program. Again, the list goes on and on. I think almost everyone in this room would think that those are all things that citizens in a democracy need to know. The reason why we know those things is that some brave and outraged individuals in government reached out to brave and enterprising investigative journalists, or vice versa, and those news institutions made the decision, often over government objection, that the people needed to know those things. So we have always, for the whole history of our republic, needed to have some process other than just being spoon-fed what government officials think that we should know. And the way that we have accomplished that is through a First Amendment protected free press. And this is why I think that the way that Ed Snowden handled these disclosures is so important. It would have been a trivial matter for him to press a button and to publish all of these documents in an instant. And instead, and you saw him discussing this in the film, he said, I'm 29 years old, I've spent my life in the intelligence community, I have certain individual biases, and that's not the best way for these decisions to be made. I want to turn them over to professional news organizations who have a history of being able to make these judgments. We may not agree with all of them, but that is the way that throughout our history we've sort of balanced these competing needs of the public's right to know and the nation's need to defend itself. These are hard questions sometimes, and let me just go back to one of those examples, which is the torture at Abu Ghraib. People like to have two categories, disclosures that are in the public interest and disclosures that harm national security. It's hard to argue that the publication of U.S. soldiers torturing Iraqi prisoners didn't lead to real harm. And in fact, I think that a lot of soldiers in Iraq were killed because of those photos. We certainly created a lot more terrorists by broadcasting those images around the world. And it's equally hard to argue that those images should not have been published. That even though their publication did cause harm to America's image and its security, it was absolutely necessary for citizens to know in a democracy that our government was doing those things in our name. So again, these questions aren't always easy, and we rely on our free press in consultation with the government to make these hard judgments.
Actually, I want to latch onto that because what Ben said is, it is really important, and that's the argument that yes, if there is some harm, sometimes we accept that risk. This is why we have the press, is to sort of arbitrate the questions of public interest. That's their role in a society that has a free press. But for all of the people in the room, because I know we have people from the FBI, we have people from the military in here, who get the emails about this and who get the government's spin on it, I want to be clear that while there are risks and there are harms, in publications, in disclosures, and, these things do happen, when we talk about these documents specifically and these disclosures about mass surveillance, it's important that we remember what the government was really concerned about. This is a news report from the Guardian newspaper in 2013 from the most classified documents sort of among the archive that was passed to journalists. And it revealed why they had classified mass surveillance technologies to such a high level. And to read it, it says, the UK intelligence agency, GCHQ, has repeatedly warned it fears a, quote, damaging public debate, end quote, on the scales of its activities, because it could lead to legal challenges against its mass surveillance classified internal. And this is really what we saw again and again and again as I and the journalists were discussing this in Hong Kong, and what I had discussed with my colleagues internally was the fact that the government wasn't really concerned about lives. It wasn't concerned about the loss of material, of ships at sea, anything like that. They were concerned about what they call internally in documents lawfare. They were concerned about the fact that citizens would go, look, these programs violate our rights in very real ways. These are novel authorities that were passed largely in secret or interpreted into being by secret courts, and they're only restrained by policy, not by law. And this is something that we really have to watch out for. Because once we cross that bridge, where we say, all right, the government can classify things not because they fear grave harm, serious damage to national security or anything like that, but because they're concerned about embarrassment, they're concerned about lawsuits, and they're concerned about political prestige, suddenly we're living a very different kind of society from the one that we expect our politicians to be instituting on our behalf.
Someone wants to know whether you have any regrets about what you've done.
I actually had a conversation with Daniel Ellsberg, the man who leaked the Pentagon Papers, about the Vietnam War, about this, because he's sort of a very kindred spirit in this regard. He was also charged under the Espionage Act. They were going to throw him away, put him in prison for life, until eventually it came out that Richard Nixon had offered the judge in his case the directorship of the FBI if he would wrap the case up quickly. And eventually the case was dismissed for misconduct of that and other things such as rape, psychologist's office. So he understands what this is like. And he told me that after thinking about this, since the 70s, he had one regret, and it's one that I'm very sympathetic to, which is that he should have come forward sooner. He's convinced that by revealing the fact that we had lied our way into the war, the basis of the representations the government was making to the public were not true, and the highest officials in government knew they were not true, but made them regardless, for the purpose of continuing a war that we knew we could not win at the time, and was only being continued to save political reputations rather than advance the national interest, American soldiers were dying. People in Vietnam were dying. Innocent people around the world were suffering for this. Similarly to mass surveillance, the longer that I waited to come forward, the longer I had to wait to be certain that I had a civic obligation to do this, as opposed to just I thought it was more the right thing to do. The more these programs became entrenched, the more difficult they became to be contested by the public. And I do think if I had come forward a little bit sooner, we would be in a better position for rolling these back. And I do regret that I took so long to stand up.
We had Daniel Ellsberg and his wife in the last of these Davis-Levin First Amendment conferences. So we share your affection for them. This is actually, I guess, a linked two questions. So one is mostly to Ben. What's the hardest part about defending Edward Snowden? And then to you, Ed, what are your thoughts about coming back and standing trial? This is on a piece of legal notepaper, and the follow-up is, I am sure you would have the best team of attorneys in the world volunteer to defend you. He already does.
I think Ben can take these both down probably in one crack.
I think so. So as usual, I want to give two different answers to this question. The biggest challenge to offering a defense here, and the reason why Edward is joining us over a Google Hangouts rather than either, being in this chair or being here, is because there is no defense under the current state of the law for the charges that have been levied against him. He faces multiple counts under a law called the Espionage Act of 1917, which was passed during World War I. Actually, the ACLU was formed in part in response to the Espionage Act and the way it was being used then. But this law, is mainly aimed at spies, that is, people who sell the nation's secrets to foreign enemies. The first time that it was ever used for someone who gave information to the public, to the press, rather than to a foreign adversary was Daniel Ellsberg's case in 1971, and Ed told you how that one ended. But since then, the courts have essentially made clear that the government has very little burden of proof in these cases. The government doesn't have to show that the disclosure of the information caused actual harm. It doesn't have to show that the information was properly classified. The defendant isn't able to use as a defense that some of the information disclosed led to legal rulings that the government's conduct was illegal or unconstitutional, that it led to the highest journalism awards. There's no balancing of the public interest against government claims of harm. Essentially, all the government has to show is that the defendant, was aware that the information was so-called national defense information, and he was aware that the people that he was giving it to were not authorized to receive it. In Ellsberg's trial, before it blew up, he had intended to use his trial to make his case to a jury and the public. And there was a moment in that trial when his lawyer said to him, Mr. Ellsberg, why did you do what you did? Why did you Xerox copy in those days, the Pentagon Papers, and give them to the New York Times? And before he could answer, the prosecutor said, objection, relevance, and the judge said, sustained. It was not a relevant question. Edward Snowden would not be able to explain to a jury of his peers why he thought that he needed to do what he did, and all of the things that have happened in the year and a half since then would have no bearing and no relevance whatsoever. So, so that's why when people say he should come here and face the music, let's be very clear what kind of tune that would be. What they're really saying is that he should be in a solitary confinement cell probably for the rest of his life, which would be the almost certain result of a trial in the United States. Now, you can take that position. And you can say, I think that's the right outcome, but be clear that that is what it is that you're advocating for. You're not advocating for a trial in which we could have this debate in a courtroom and a jury could weigh the various equities of whether these disclosures were worthwhile or not. What you're saying is he should be in a U.S. prison under special administrative measures that limit his contact with the public and with journalists, and would even require lawyers like me to sign non-disclosure agreements. So that's one answer. The second short answer about what are the challenges of this kind of representation? Typically when you represent a client, your goal is to achieve the best possible outcome for that client, to offer that client the most possible protection. Well, you all just saw the film. This is not a client who is particularly interested in protecting himself. This is someone who was willing to take enormous personal risks in order to bring the public into this discussion. And from the very first time we communicated, he made clear that if there was any, essentially, there was nothing that we could do that would make his legal situation any worse. And therefore, that the goal of our relationship, the goal of this representation should be to maximize his ability to advance the debate that he was able to help launch with these disclosures. And so most of what we do is rather than saying, how are we going to make your life materially better? It is, what country should we be making a push in right now? Where can we affect a debate that's taking place? Where are these issues most in play? How can we use this limited amount of time that he has and that we have to make the maximum impact?
Ed, you want to add anything to that?
I think he's
pretty eloquent.
Probably covered that much more professionally than I could with my amateur armchair analysis. But the basic challenge there is, as Ben said, there's no fair trial on offer right now. My legal team has worked exhaustively to speak with the government and seek fair trial, an open trial, where we can really get an answer about the lawfulness and propriety of these programs and do things in a just and fair way. And I would be very happy to share a docket with James Clapper, but I'm not sure they're prepared for it.
This is another Twitter question, so you can check whether I'm reading it accurately, because we're going to have it on the screen in a moment. What should government transparency look like? And I'd like to add to that, would there be a classification system? What would that classification system be?
When we think about transparency, we've got to think about the basic principles, right? A lot of people go, well, if you care about transparency and whatnot, why do you seek privacy? The government wants privacy too. That's what their secrecy is. But they're really looking at sort of the two parties as equivalent. And as we sort of discussed earlier, philosophically, there's always an imbalance of power between the individual and even the body of citizenry and the government above them. Privacy is for the powerless, right? Transparency is for the privileged. That's really the difference there, is they have to be accountable to us. We have to understand their behaviors to be able to control them because they're so tremendously empowered and ultimately dangerous relative to us. Now, we hope they'll do the right thing, and more often than not they do, but we have to have some way of balancing that out. So when we think about how do we implement this, it's more of a question of what do we know doesn't work. And again, the secret courts with 34,000 requests over 33 years, where they only say no 11 times, and we didn't know about this, we didn't know how it was being applied, we didn't know what the decisions were, that wasn't working. Things are starting to get a little bit better. The ultimate answer to this is we cannot allow secret laws or secret interpretations of laws in this country. We have constitutional rights that are not granted by the government. They're inherent to our nature. Every man, woman, and child is born with these rights, and they belong to us. And if they're going to be infringed through some kind of legislation, if they're going to try to carve out exceptions, we have to know about how this works in order to be able to contest it. And to now, we haven't had that. Today, we still don't have that. But we're starting to head in that direction, and I think that's the vital first step. We have to know what powers and programs, broadly, the government is using.
So we need a classification system, but we've never had one that works. And the estimates for how much classified information is improperly classified, I mean, the most conservative ones, and I doubt there's anybody in this room, even those of you who have security clearances, who would say that half of the information that's classified is properly classified. The better estimate is that maybe 5% of the information that's classified is properly classified. It gets classified at an alarming rate. Thousands and thousands and thousands and thousands of pages every day. It's a hard problem in a democracy, and it's a hard bureaucratic problem because no one's ever gotten in trouble for overclassifying something. People are worried about getting in trouble for underclassifying something and being blamed for that. So, look, there are categories of information that we can all agree need to be secret. If we're going to have undercover spies, we can't reveal their identities. We shouldn't be revealing troop movements. If you reveal surveillance targets during ongoing surveillance, and that's appropriate, you can cause some serious problems. But the amount that is secret it so vastly exceeds the interests for keeping that secret, and what you see over time is that the rationale for classifying moves from how do we protect the country to how do we protect ourselves, how do we protect our prerogatives, how do we protect our reputations, and information is concealed, again, not because enemies will harm us, but because if the public knows this, we will either be punished or we'll lose our budgets or we'll lose our authorities. So,
yeah, to speak as somebody who's actually sat on that side of the classification boundary, and to the people in the audience who work at CANEA or Rochefort or anywhere else handling classified, you guys know this too. When you send your emails, your lunch notes could be classified. These things there's a natural momentum to it that's there. And once these things are classified, they almost never become unclassified. There's a 25-year review period, a 30-year review period, all of this. And what this shows is in the leak of in the wake of mass disclosures that we've seen through WikiLeaks from 2013 and that are very likely to continue in the future, the problem is we're trying to control too much information. And too many people have access to it. We need to think hard about what is really secret. What is the bare minimum of information that needs to be protected on a need-to-know basis? And what wider body of information do we have an obligation to share to make sure that everybody knows and can work from it, can produce on the basis of it? Because when we talk about things that are actually secret, the positions of troops in war zones behind enemy lines, these things are intensely secret, but they also age off very rapidly. After the troops have been gone for a year, the war is over, that information no longer has the same necessity of being protected. And that's what we need to start thinking hard about, how we can limit the amount of classified information we produce, because if it's classified unnecessarily, it is less valuable from a policy perspective and broadly from a social perspective.
There's another problem here, actually, with overclassification, and it has to do with the security clearance issue. There's something like 5 million Americans now who hold some kind of security clearance, and it really functions as a code of silence. Now, in order to even be employed in defense or intelligence, even if you're not working for the government but working for one of the many contractors, you have to have that security clearance. If you lose that security clearance, you lose everything. You lose your profession, you lose your community, and so it's a very, very coercive way that this information is controlled. Most people don't need the deterrent of a prosecution under the Espionage Act. They know that if they fall out of line, they're going to lose their ability to make a living. Another problem with this, and there's a wonderful story that Daniel Ellsberg tells in his book. He warned Henry Kissinger when Kissinger was going into government about what would happen to him once he was read into these secrets. That at first it would be intoxicating, to get to finally see the real sort of secret history of how things really operate, but that before long he would start to have contempt for people who were not in that circle. And he would disregard the opinions of people who didn't hold security clearance. I think you see a lot of that in the last year and a half, that what you might call the national security priesthood and its members really think the rest of us just don't get it. We don't understand how bad these disclosures are because we're not getting the same memos that they are. Well, you know what? We have eyes and ears, so we can look around the world. We're not, totally ignorant just because we don't get to see a few pieces of data that happen. Right, exactly.
So we're running out of time. I want to ask, I guess, my own question. Ben and I were talking about a book written by a late friend of ours, Robert Cover, which is called Justice Accused. It's about judges who were themselves against slavery but said they were obliged to return fugitive slaves. And Bob talked about what he called the moral formal dilemma. So there are those who say the law compels me to do X, Y, and Z even if I don't like it. And there are those who step outside and say, wait a minute, there's immorality there, there's something higher. It's sort of paradoxical to some, I suppose, that you are relying on constitutional rights, on the law, to also say I can step outside some of the laws. I wonder what your response to that would be.
I think when we look at this this whole paradigm of lawfulness and what purpose it serves for society, law is a lot like medicine. If you have just enough, it's very helpful, but if the dose is too high, it's fatal. If we have a society where we reach the ideal of mass surveillance, we can all be watched for and this is, let's say, there are no constitutional questions or anything like that. But all of our activities are being tracked, monitored, stored. The perfect enforcement of law is not necessarily a social good. It could actually be fundamentally threatening to us because law breaking is one of the most important means of progress for society. If people did not break the law, we would never have had the American Revolution, and they also had to do that secretly. If people did not break the law, prohibition would still be in place. If people did not break the law, we wouldn't have the progress against drug prohibition that we have today. If people did not break the law, slavery would still be in place. So I would argue that there is a civil value to law breaking. Now, that doesn't mean that people should do it all the time. That doesn't mean they should do it lightly. And of course, we do have a social tradition that argues for lawfulness in general cases. But ultimately, morality prevails. Morality prevails because that is why we are here. The pursuit of happiness, life and liberty, are the foundations of our society, not law. And on that basis, I think there is an argument to be made that there are real questions to be asked about how do you hold whistleblowers to account? How do you punish them accordingly? And this is something, I don't think that I should be free from punishment. I don't think I should escape and get no punishment. And I have volunteered to go to prison in conversations with the federal government. But they're not concerned about the law. And this is a key that, again, is one of those distinctions that's important for people in the room who work for the government to understand. The difference in representations that governments make privately and publicly. Publicly, they say, we're not spying on everyone. Privately, they are. Publicly, they say, we care about the law. We are a nation of laws. The rule of law is our highest principle. Privately, they're more concerned about outcomes. They're more concerned about effects. They're more concerned about powers. And in this case, and most whistleblowing cases, about deterrence. They are much less concerned about the right or wrong of what any individual has done than what impact and effect it may have on other people who are watching. And it's on this basis that we need to, again, look to the standard that are being set by our government officials at the highest level. The most senior official in the United States, James Clapper, the Director of National Intelligence, he lied to Congress, didn't even get a slap on the wrist. He committed a felony on camera in front of 330 million Americans. How can we say we're a nation of laws? How can we say the rule of law is the most important value to us when we can't so much as be troubled to do an investigation of open and notorious challenges from our most powerful people in the country?
So I think there's a real irony.
Thank you.
I'll wait for Ed's computer to stop shaking. I think there's an irony in that this is not the first time in our history when a dramatic act of law breaking was the catalyst for revitalizing lawful democratic oversight. It's very interesting to see what's happened since 2013. Before 2013, we saw Congress standing silent while national security officials lied openly about these programs. There was no real debate about reining in intelligence programs. And now we have bipartisan bills in Congress to increase oversight, to add some kind of adversarial process to the secret courts. Before 2013, as we discussed, the challenges to the constitutionality of these programs were tossed out by courts, not on the merits, but on secrecy grounds. And now we've actually seen all three branches of government engaged in a really interesting and historic debate about whether we've drawn the line in the right places. And I say it's not the first time. We had a great debate about intelligence oversight in the 1970s. Not everybody remembers how that began. It began with a bunch of activists breaking into an FBI office in Pennsylvania, stealing all of the files, putting them in a suitcase, driving away, and then mailing them to the Washington Post, which started a chain of events that led to the exposure of COINTELPRO. It led to the Church Committee hearings. And so it is an irony that sort of sometimes if you let the system run its lawful course, it runs the wrong way, and you do need somebody who is willing to dramatically step outside of that, oddly and ironically, to reinvigorate the oversight that we all want and need.
I'm afraid we're really running very close to the end, so final thoughts, both from Ed and from Ben?
I would say the thing that I want to leave you with is an idea to inoculate yourself from simply accepting the representations of anyone, myself included, when it comes to how the government works, how these policies are applied, and think about the kind of society you want to live in and how to realize it. What kind of values do you care about? And to care about not just enough to believe in, not just enough to give lip service to, but to stand up for and do something about, to protect and defend against people who are prepared to do you harm, who are prepared to put you in jail, who are prepared to do anything to resist you. And even on a simpler, more cooperative basis, when we think about the government, when we think about sort of this reform period we're going through right now, how do we balance the desires of government with the needs of the public? And we're going through a period right now where the government is saying we need new cybersecurity powers, right? This is constantly being discussed. It's coming to Congress soon. We know it's coming. And they haven't even reformed the surveillance programs that are still today, when you pick up the phone, making records of the calls you make. This kind of thing has to happen. We have to think about how do we regulate this in a strong and durable way. We've got policy being provided to us today, and government officials, when they defend these programs, when they defend mass surveillance, they go, these programs aren't abused. Your rights aren't being violated. Yes, they're broad. Yes, they collect everything. But, we're very careful. We're not going to make mistakes. We're going to act responsibly. And this is convincing. This has convinced me, and this has convinced many other people. But when we look at the actual record, That's actually not true. And this is why that question of deception is so important. We need to understand what's actually happening, and we need to actually chase the truth. We need to seize the truth. We need to pull it out of the darkness and bring it to the light, because what we get from that are stories that say, despite the claims of government, they broke the law. They told us they didn't break the law. They told us they followed the policies perfectly, but that was not true. Even the secret court, that rubber stamp court that I keep going back to, that never says no, even that court that is just so in the government's corner said, hey guys, this is really crazy. This is getting out of hand. You told us that you weren't abusing these programs, you weren't running these searches, and yet for 3 years you were doing precisely that. In fact, the safeguards that we put on you have been so frequently and systemically violated that it can be fairly said that the oversight regime never functioned effectively at all. We need to remember that in every policy debate. We need to remember that in every question of lawfulness in civil association. And we need to bring it back to that basic principle of what do we believe in? What kind of society do we want to have? What kind of rights matter to us? For me, I remember the internet before it was being watched. I remember what it was like, even just to be in Hawaii and to walk down the street, to be in the ocean on the beach and feel like I was just by myself. I don't want daily life to be like that. I don't want to think about when I'm in the mall what my cell phone is saying about me, what the cash register in the store is saying about me, what the bus is saying about me when I swipe my travel pass. I don't want to think about what my passport is telling not just my government that I trust, but all of the bad authoritarian governments around the world that I do not trust. We need to find ways to protect our rights, to enshrine our rights in our systems, in our technology, and in our behaviors, so that no matter what any government around the world tries to do, we remember that there are more of us than them, and we can win. We can say, these are our rights, and we will keep them.
Okay.
Shouldn't that be the last word?
Huh?
Shouldn't that be the last word?
Well, I have to say something.
Yeah.
Thank you. Mahalo. I like that. Yeah. I can hear you.
Well, Ben correctly says you should have the last word. That was very eloquently said. I do want to thank you, Ed and Ben, for being here, all of you for coming out on Saturday morning and Valentine's Day to boot, those who've been watching this, and of course the sponsors and all those who work to make this possible. I once noticed in a boring meeting that if you take rule of law and rearrange the letters, you have awful lore. I guess the challenge is to tell where it's awful lore and where the rule of law is so important. Thank you all.
Thank you so much.
Sure. Making dizzy?
Thank you. Thank you.